Okay, the next is 1239. And 1239 provides for ordinary income if there is a sale of depreciable property between related parties, even though that property would ordinarily carry with it maybe 1250 recapture, but generally long-term capital gain.
It's usually 1231 gain.
Yeah. Well, you're right, 1231 gain.
Yep.
So in this context, let me just paint a picture, and I've seen this before, where S Corp owns a piece of real property. Here, it might be an apartment complex. And the sole stockholder of S Corp passes away, and they want to liquidate the company and take advantage of the stepped-up basis in the stock. Normally, that would, if we have long-term capital gain assets inside the company, then the liquidation of an S Corp, as you know, unlike a partnership, it does trigger gain, but that gain would increase basis of the stock, and with the step up, it would be like a double increase in basis, so that there would, when the assets come out, there would be an offsetting capital loss. So as long as that happened in the same taxable year, then great, there's a netting. But the problem, the disconnect could show up if that sale, that deemed sale by the S Corp, generates 1239 ordinary income, let's say. So you'd have ordinary income on the way out, basis increase, but then a capital loss.
That would be bad.
That would be bad, typically. So how do you get around this? Well, what if the S Corp, instead of owning the property directly, were an 80% member of an LLC that owned the apartment complex?
And the partnership was formed the day before you liquidate the S Corp?
Well, let's assume it's old and cold first.
Oh, okay.
So old and cold, so one taxable year before. Okay.
Not in contemplation of.
And we're already dealing with the fact that the poor stockholder is old and cold. But anyway, golly.
That's in poor taste, Stephen. A little respect for the recently departed.
Okay. So if the LLC were formed, let's say the death occurred today, so the LLC was formed December 30th of 2017, old and cold. So then we liquidate, and the property does not come out of the S Corp as such, because the property is in the wrapper of an LLC, so there is an LLC interest coming out of the S Corporation instead of the underlying property. So, as we know, there is look-through in a partnership or an LLC. There's look-through for 751 recapture of ordinary income. There's look-through for certain characterizations like the 28% gain assets, gold and art and things like that. There's look-through for 1250 recapture. But the question here is there look-through for 1239 purposes? Is the LLC interest a 1239 asset? There is some good authority, I think, that it is not 1239. There is and I have the good authority based, first of all, on a revenue ruling going back to Section 72, which says that if a husband and wife sold 100% of an LLC to a related corporation, so that LLC became wholly owned. Remember, this was before 99-5 and 99-6, that the government said that was bad. That transaction was bad, and the sale of the LLC interest was, in effect, a sale of depreciable property for 1239 purposes. So, first of all, I have comfort that this is not a 100% transaction. This was only an 80% transaction.
We don't know how much we can limit it, because I agree with you. 72-172 involves a sale of 100% of the partnership interest owned 50-50 by husband and wife to an S corporation in which they own 100% of the stock. But the partnership went away.
Yes.
Here, the partnership's not going away.
Right.
So I think we might be able to distinguish it on that grounds. I wouldn't totally rule it out, but this is like a 50-50 kind of thing.